3 major Supreme Court decisions are dropping by the end of this month. Together, they could rewrite the rules of the country. We are looking at a permanent restructuring of who holds political power, the legal definition of who actually counts as an American, and whether the stranger behind you at the grocery store is carrying a concealed weapon. I'm Brian. This is the Exhausted Majority, helping you navigate the polarized noise. Most media coverage gets caught up in the politics of who is winning or losing. We are examining the legal fine print, focusing strictly on how these cases work in practice. If you tune this out, you surrender your understanding of how the rules governing your daily life, your identity, and your safety are about to change. For nearly a century, the federal government has relied on independent agencies. Congress designed these bodies to act as technocratic shields, protecting the public from the political mood swings of whoever sits in the Oval Office. Take the Federal Trade Commission, for example. A new case, Trump v. Slaughter, is a direct legal assault on that entire century-old protective framework. The administration's argument relies on the Unitary executive theory. This is the legal argument that the president possesses total, unreviewable control over every single person working in the executive branch. To get there, they need the court to overturn Humphrey's executor. That is a landmark 1935 precedent, specifically protecting agency heads from being fired unless there is a genuine for-cause reason, like actual neglect or illegal activity. Erasing that precedent destroys the technocratic shield. It takes power away from expert referees and hands it directly to the political impulses of the president. Let's look at the immediate consequence. If the administration wins this case, the president gains the authority to fire the chair of the Federal Reserve simply because they do not like what interest rates are doing to their poll numbers. The Federal Reserve is the central pillar of the American economy. If the FTC loses its independence, we lose the referee that stops your internet provider from secretly packaging and selling your browsing history. If the Consumer Financial Protection Bureau gets brought under direct presidential control, we lose the block on predatory payday lending schemes that target working families. And manipulating the Federal Reserve directly impacts the benchmark interest rate. That rate dictates the cost of your mortgage, your car loan, and your small business line of credit. These agencies act as the direct referees of your financial life. Stripping their independence changes the economic game for every citizen. We have already seen a preview of this executive power grab. The administration recently attempted to remove a Federal Reserve governor before her term was up. Her name is Lisa Cook, and she is the immediate, real-world target of this legal theory in action. This economic chart shows a stable baseline of inflation and unemployment transitioning into the 1970s. But the Nixon administration successfully pressured the Federal Reserve to keep interest rates artificially low for political gain. The result was a disastrous decade of stagflation. It took Paul Volcker, acting entirely independently and ignoring massive political backlash, to finally break the inflation cycle by drastically raising rates. True economic stability requires that kind of independence. An elected politician facing an upcoming election will almost never risk their own career to make painful, necessary financial choices. This puts the conservative supermajority on the Supreme Court in a difficult position. Can they legally protect the Federal Reserve's independence while simultaneously handing the president at-will firing power over the FTC? Threading that needle, if it is even possible, will be the most consequential legal maneuver in the entire Slaughter ruling. While Slaughter redefines the executive's power over the people inside the government, our next case redefines the executive's power over who actually belongs in the country. Of all the cases on the Supreme Court's docket this term, one stands out. In a historic first, the president personally attended the oral arguments for Trump v. Barga. At the center of the dispute is Executive Order 14160. The order seeks to deny birthright citizenship to children born on U.S. soil if their parents were unauthorized immigrants or temporary visa holders at the time of birth. The handwritten text of the 14th Amendment Citizenship Clause stands directly in the way of that order. Written after the Civil War, it was meant to ensure that anyone born here could never again be relegated to a permanent legal underclass. This case pits a radical revisionist theory against 150 years of settled law, a decision that will define the very meaning of American citizenship for the next century. The revisionist view defines citizenship as a social compact requiring mutual consent. It argues that by entering the country without authorization, the parents and their children reject that compact and never truly enter the jurisdiction of the United States. Conservative scholars like Keith Whittington champion a different, originalist view. They argue that subject to the jurisdiction simply means you are physically present under the authority of our laws. If you break a law, you face our courts and serve time in our prisons. Historically, the only exceptions to birthright citizenship were children of invading armies or foreign diplomats. These groups carry sovereign immunity and cannot be prosecuted under our laws. Unauthorized immigrants have no such immunity. Which of these theories the court chooses will determine who can claim the protections of the American government for generations to come. Away from the legal theory, the actual human stakes are immediate. We are talking about children who grow up playing Little League, speak English as their first language, and attend American public schools. If the revisionist view prevails, hundreds of thousands of those native-born children would be left in permanent legal limbo, born here but stateless. This shift would enable mass deportation, detention, and family separation on a scale this country has never attempted. Currently, no system exists to track citizenship based on a parent's immigration status at the moment of birth. Hospitals, courts, and local governments would be left with zero federal guidance to handle the fallout. Redefining citizenship would require a massive government infrastructure that simply does not exist, turning the simple act of birth into an unsolvable crisis for local institutions. The administrative collapse inside hospitals and schools would spread into our election systems, pulling the voting eligibility of every American into legal doubt. This is because a standard birth certificate would no longer be considered sufficient proof of citizenship. It would only prove where you were born, not the legal status of your parents at that moment. Adults born to parents on temporary visas or without authorization could have their citizenship stripped entirely. State governments have no voter registration systems capable of handling this burden of re-verification. Millions of lifelong Americans would now need newly verified documents to prove they are still citizens. The government lacks the infrastructure to manage an exponential backlog of this size. Reinterpreting the 14th Amendment would trigger a systemic failure, paralyzing the document registries we rely on to verify our legal identity and right to travel. Now, let's look at what comes next. This text is the Second Amendment of the U.S. Constitution. It is currently at the center of a Supreme Court case called Wolfrod v. Lopez, which forces a direct constitutional collision between the right to bear arms and the rights of private property owners. The case challenges something known as the vampire rule. Like a vampire requiring permission to cross a threshold, this rule says a gun owner must obtain explicit advance permission from a property owner before carrying a firearm onto private property open to the public. This rule dictates the daily reality for over 86 million people across Hawaii, California, Maryland, New York, and New Jersey. But during oral arguments, the court's conservative majorities signaled deep skepticism. Applying the doctrine established in its recent Bruin and Rahimi rulings, the court appears likely to flip the default entirely. Guns would be automatically permitted everywhere unless a business owner actively posts a sign barring them. Consider what that asks of a local operator, like a restaurant owner in Newark or Honolulu during the Saturday morning rush. To maintain the gun-free baseline she had just last week, she now has to make a public political statement. She may face blowback or lost customers simply for wanting what business owners in 45 other states already have by default, the right to stay out of the culture war entirely. By removing that default legal cover, the court is stripping local owners of their neutrality, effectively forcing federal ideological battles into local dining rooms. The gun case is one piece of a larger structural pattern emerging from the court. Taken together, the rulings of the 2025-2026 term reveal a deliberate upward concentration of power. In Trump v. Slaughter, the administration is attempting to strip independence from career civil servants and the heads of agencies like the Federal Trade Commission. Their argument rests on the Unitary executive theory, the idea that the president has total, unreviewable control over every single person working in the executive branch. To get there, the court would need to overturn Humphrey's executor, a 1935 precedent that has protected agency heads from being fired without a genuine for-cause reason, like neglect or illegal activity. If slaughter redefines the executive's power over personnel, our next case, Trump v. Barbara, redefines who counts as an American. It is a direct challenge to this clause in the 14th Amendment. The case centers on Executive Order 14160, which seeks to deny birthright citizenship to children born on U.S. soil if their parents were unauthorized immigrants or here on temporary visas at the time of birth. While Wolfrod federalizes local domains, Slaughter expands executive control over the civil service, and Barbara narrows who belongs to the American body politic. Conservatives champion federal mandates, while moderates defend local control. Every arrow points toward upwardly concentrating power. This is a systematic reconfiguration of the republic, moving authority away from local communities and toward a presidency with fewer constraints than any in modern American history. The primary tool for this rapid consolidation is the interim docket, also known as the shadow docket. This allows the administration to impose sweeping structural changes through emergency orders without full legal briefings, public scrutiny, or transparent accountability, often before a single oral argument is heard. Justices Jackson, Sotomayor, and Kagan are sounding alarms, targeting the court's expanding use of this docket. They are writing opinions for tomorrow's history books, warning that these emergency orders are being used to bypass the traditional, deliberative process that keeps the court accountable. This creates a unique crisis for the exhausted majority, the cross-partisan group of Americans who value institutional stability over the noise of the culture war. The mechanisms of democracy are being rewired, precisely while this middle is looking away, overwhelmed by the daily political cycle. The only counterweight to this quiet, structural reconfiguration of the republic is an engaged public that refuses to let the interim docket rewrite American power in the dark. If you look at the news lately, it is tempting to just throw your hands up, tune out, and completely disengage from the political process. The noise is constant, and the sense of systemic exhaustion is real. But we need to look at the data. Roughly 58% of Americans, the clear majority, actively disapprove of our political trajectory. But screaming headlines and culture war theater take up the oxygen, creating a false illusion that extremes are the majority, while the largest group feels squeezed into the background. Don't let that feeling win. If the largest, most reasonable group of people in the room stops participating because they are too tired to argue, the only voices left are those at the edges. For the partisan fringes, that isn't a side effect. Inducing that burnout is how they gain control. The exhausted majority is not some fringe alternative faction. It is the actual mathematical center of gravity in the United States. When you recognize the sheer scale of that 58%, the political exhaustion feels less like a personal failure and more like a manufactured obstacle, one that can be cleared by sheer numbers. Recognizing that power matters right now. As the extremes tear the system's puzzle pieces apart, the exhausted majority is the only group with the numbers to reassemble it. Doing that means looking past the noise. When you vote, it cannot be about screaming headlines or culture war theater designed to keep you angry. We have to shift our criteria towards stability. That means electing people who genuinely respect institutional guardrails and the long-term health of our republic. This is the pragmatic work of the majority. We exercise our power not in the comment section, but at the ballot box. We have to defend the foundational principle that no single branch of government should ever concentrate this much authority without clear constitutional checks. To reclaim those checks, we must look at why our legislature has become so unresponsive to the middle. This leads directly to how we draw our voting districts, the gerrymandering crisis, and the specific reforms needed to make Congress represent the people in. Ultimately, structural reform has to be won in Congress. But it starts with an exhausted majority that realizes it actually holds the power to fit the pieces of this country back together.